Mr. John Oloyede joins us now. He's a legal practitioner. Thank you for coming on this morning.
Good morning.
Well, we've seen that, but ever since then, so many things have changed. Yeah. Explain some of those things that happened to us.
Well, it's not. First of all, we have to proceed on the premise that the Supreme Court has given its judgment, and while those of us here can keep on ruminating, talking, and proffering ideas about what should be, what should not be, that judgment is binding on all of us. Nothing can change it. Now, what actually happened is, you see, we have separation of powers, so to say, under the Constitution, and lawmaking is the prerogative of the Parliament. But there are instances where courts of the land actually make laws when they make judicial pronouncement, especially on novel matters such as this. And that is the position that the Supreme Court has taken. It is not out of place. I mean, for instance, there was an amendment to a particular provision of the Constitution, and the Supreme Court, first of all, I am of the opinion that what had transpired from the Federal Court to the Court of Appeal was actually wrong.
Oh, okay.
There is no basis for saying that somebody who had been in power and his election was nullified, he went for re-election, because he was now re-elected, it is the time will be reckoned from the time he took the second oath. I believe that, I have always believed that the proper thing to do is, when it is the incumbent that has had to go through a re-election process, the time should remain as it was. But when it is somebody entirely new who had never taken an oath of office before, then the time will start running from the time he actually takes the first oath of office. That has always been my position. Now, what the Supreme Court has done is to take the law, the amendment, a step further, to actually state the law as it is. That it can never be imagined that the intendment of those who drafted that rule, because there was a mischief. The mischief was to prevent a situation where somebody coming in afresh will not have his 4 years, and somebody who has been there will stay for more than 4 years. That was the mischief. But because the drafters, I believe there was a little bit of laziness. The drafters of that particular provision were not proactive enough to think ahead of a situation where, the incumbent has gone for re-election, a nullified election, he has now been re-elected. They did not, just one phrase, provided that in the case of somebody who had taken a first oath, the time of reckoning will start from the first term. That was the problem. That was the lacuna. And that's what the Supreme Court has done. It can be called judicial activism, but that is the proper thing to do.
Why then did we have the case where two acting governors, as it turned out there? Because, I mean, swearing in Captain Wada, there were those who would predicate it on the point of law also. Where did they go wrong?
Well, there were two reasons why they were wrong. Number one, there is nowhere in the Constitution of the Federal Republic of Nigeria where the President of the Customary Court of Appeal would engage in swearing in anybody. I have never seen that. And the doctrine of necessity as it applied to Mr. President in those days cannot apply here. That's one. So, the first wrong step was somebody who did not have the capacity to swear in
spelled out by the law?
Spelled out by the Constitution. Okay. I mean, when you say law, the full force of it is not clear enough. But let the Constitution now, because that is the ground norm. That is the law on which all other laws are based.
Okay.
So the Constitution says the chief judge of a state. Why should he be the president of the Customary Court of Appeal? That's number one. Number two, as the chief judge of the state said, the Supreme Court did not make consequential orders. I don't agree with that, because knowing their peculiar position, the justices of the Supreme Court, they knew that after their pronouncement, we can go nowhere else except to God. And I don't think God is interested so much as to come practically down to earth, to come and take charge of affairs of men. I mean, not in the spiritual sense of it. So, if the Supreme Court, that although you say the court is not a Father Christmas, and that what a party has not asked for, the court will not give them. But in making such a far-reaching decision, a decision that is very novel. It's unprecedented in the annals of Nigerian history. The Supreme Court could have gone a step further to make pronouncement, because knowing Nigerian politicians, there is going to be a big fallout. There's going to be a lot of cases. Lawyers will go to court and interpret and, say all sorts of things about this decision. There could have been pronouncement knowing that there are peculiar situations, as in Kogi, for instance, Bayelsa, for instance, because this should impact on the primaries.
Hypothetically,
before we go to Bayelsa now, but let's also look at Kogi critically now, because the party, for instance, has also instructed now, saying, well, the Speaker should, as a matter of fact, vacate office and return to the Assembly as Speaker, and allow the governor-elect to take the oath of office.
That is lawlessness. I don't think the party has a say in this. You've presented somebody, the law. No amount of fact can override the law. The law says, in the event that there's a vacancy in government house, so that somebody is out by reason of death or whatever, or removal, the next person is the Speaker.
But again, some say Kogi's status quite different from the other.
I don't think there's anything peculiar.
Because first, they have a governor-elect.
Okay.
The elections was December last year, and a governor in waiting. So if you're taking off the governor there, then you should automatically swear in the governor-elect.
Now, if you talk of peculiarity, my way of looking at it is this. A governor has been elected. Now, taking it back to, you see, when there is a decision of a court of law, the former governor, the governor that has now been ousted, was there because of some court pronouncements. To that extent, you can say, every step he took while in office, backed by judgment of Federal High Court and the Court of Appeal, remain valid. Every step he took. Now, the Supreme Court now of the land now says, look, he ought not to have been there as far back as May 2011. He ought to have vacated office. Now, the implication of that is that there was a primary election held, I think January 2011, and somebody was put there. If he had left office, it's most likely that the primary election then would have been the one that would have produced the present governor. But there was a subsequent primary election, and that was because of the fallacy in the now known to all of us in the decisions of the Federal High Court and the Court of Appeal. So my own view is this, that it is no longer automatic for Governor Captain Wada now to just say, because I've been elected, all things are passed away, all things have become new.
Well, two things pops up there, but hypothetically now, what if the Chief Judge had sworn in Captain Wada?
I don't think, it is inconceivable, but it is inconceivable that this Chief Judge that I have seen would have sworn in Captain Wada. But let us assume that he did that. It will still have been, against the order of things. Because this judgment requires a lot of studying. I am not going to be one of those who will just jump up and say, the Supreme Court was wrong, was right, this is the proper thing to do. We need to really, really, really sit down and ruminate over that decision. We need to read the full text of the decision.
Yes, while we wait for all of that now, Sir Mark, you actually mentioned the primaries while trying to analyze what happened in Kogi, and you talked about the first primaries leading up to that election we saw in April. Now let's look at Bayelsa. There was also a primaries, which actually threw up the former governor Timipe Silva. Now, if we look at all of that, what has happened in Bayelsa State, how do you interpret that? Do they now fall back to the first primary, or does this judgment cancel every other thing, especially the last primary that saw the emergence of Seriake Dixon?
The implication of the judgment at face value is that there ordinarily ought not to have been a second primary election in the PDP. That is the implication. That the governor's terms, all these governors, their terms ended just like all the other governors in other states in Nigeria. And so, going further with that decision, the implication is that there was really no need for a second primary election. And if that is the case, it means that the subsequent primary elections remain void. Now, you have to try and divorce the two, because I've had people talking about, does it mean that all the actions taken by these governors, are they invalidated? No, they are not invalidated. There can be no, the governor's office is a continuum. Somebody must be there at every point in time. And so long as they were there on the basis of a decision of court, that decision was valid until the day it was set aside. But on the issue of primary elections, which is different from, occupying the office of the governor, it's a party thing. What I am saying is that by this judgment, the Supreme Court has said more or less that, look, they ought not to have been there. And if they had vacated office and gone for the election, for instance, Timi Praise Silva, he would have contested the election by now.
So in this particular case, would you advocate that they conduct fresh primaries, as our previous guest did say, that, he sees a situation whereby they might have to conduct fresh primaries? Or do you see them relying on the primaries, that was conducted before May 29?
My view is that fresh primaries should be conducted. That is the Nigerian in me. The Nigerian in me says the best way to avoid controversy is for fresh elections to be conducted by, all parties interested in conducting fresh ones, so that all persons interested will come together and participate.
What about the lawyer?
But the lawyer in me says, INEC can just rely on the first primary elections.
Well, speaking about primaries, can we completely look at this entire matter from the points of law without talking about the provisions of the Electoral Act?
No, definitely not.
Then, if you look at Section 26, I hope this is the amended one, postponement of elections, it talks about, do we take that into consideration? Because there are so many provisions here. Sub 2, where an election is postponed under this Act, on or after the last date for the delivery of nomination papers, and the poll has to be taken between the candidates nominated, the electoral official shall, on a new date being appointed for the election, proceed as if the date appointed with date for the taking of the poll between the candidates. There are those who suggest that subsection 1, what it was talking about, natural disasters, other emergencies, the Commission may postpone election in certain areas based on this, because we've seen it in Adamawa State, they postponed elections twice. Some think that this court order can constitute part of the emergencies so stated here. And as such, if a primary was held months ago, they can rely on that primary and say, well, due to this emergency, that primary subsists. And so the candidates therein can participate in this forthcoming election.
That's why I said the lawyer in me, because that's talking about the law. In support of the law, this is an emergency situation. And so INEC will be in order to say, well, because we are faced with an emergency, we don't have time to start doing all these things. Then they can rely on the previous election, primary elections.
But what you see, what you see happening in Kogi, if you decide as a lawyer, or if the lawyer in you says that you can rely on previous primaries held before May 29, what do you see happening in a case like Kogi, where the elections have already been held and, there is already a governor waiting, if you like?
What I see happening is a situation where Captain Wada will go to court, and the case will take 3-4 years, and ultimately still get to the Supreme Court. And the Supreme Court will say, that is why I said the Supreme Court has made a very, very deep pronouncement, and that as the last court of resort in this country, I would have loved a situation where the Supreme Court would have made consequential orders. Consequential orders, that takes you away from the realm of, you can't give what a party has not asked for. No, because you know that they are not going anywhere else, and it flows naturally. You know that there are people out there who are spoiling for a fight. The Supreme Court could have gone ahead to make, that was why the Chief Judge of Kogi said there were no consequential orders. Because if there were, the consequential orders would be as binding as the primary reliefs. The Supreme Court could have said, this is a decision which we have made. This does not affect primary elections held before so date or held on so date. This does not affect a situation where somebody has been elected. The Supreme Court could have made such consequential orders, which will be binding, and then that will clarify so many issues. And there will have been no need for people to rush back to court again, because I can assure you
there will be many who will rush
of
back.
course,
lawyers and politicians.
well, good times anyway for them. But again, Chamberlain just went into the Electoral Act, and I felt that we should also stay there a little and see how we can explore this, submission of a list of candidates and affidavits by political parties leading up to election. This talk about 60 days, specifically Bayelsa. Again, is also in the news. The elections is just a couple of days away, which is February. Now, we wait for INEC to give us the way forward today. But again, before we hear from INEC, what should be the case, just in case there's no extension to that particular elections in Bayelsa State?
You see, Bayelsa State is a very, very complicated situation. Simply because you have a battle of judgments now. High Court, Court of Appeals, Federal High Court, Supreme Court now. Now, the Supreme Court did not make specific orders in respect of specific situations. Bayelsa, now, the camp of Dixon, they had to get a court order to compel INEC to include his name, because INEC chose not to include his name. INEC did not put any name. And now, PDP had put to, getting something done so that somebody's name will be there. Otherwise, within the time limited, PDP will have no candidate. And they will lose that state by default. So, Dixon goes to court, gets an order. Some people are complaining about the circumstances surrounding the procurement of the order. Gets an order. I don't know whether INEC has inserted the name, in which case, INEC, and there was a first primary election. Jimmy Silva's name was probably submitted. Now, there's a subsequent submission pursuant to an order of court. That order of court is yet to be set aside. The Supreme Court that could have shown more light on the situation did not talk categorically about that situation. So you have a situation where you don't have a case of emergency. You have emergencies on the neck of INEC. And it will be difficult for them to wriggle out of the situation, because by the later judgment is what any party is bound to follow. The latest judgment on any issue, you are bound to follow it, except you have the judgment of a superior court, of a higher court. Now, there's a judgment, or that maybe it's an order that says Dixon should be there. Until it is set aside, Dixon's name should be there. Now, that has taken cognizance of the Electoral Act. Presumably, every judge is presumed to know the law.
Yeah.
So we would assume that the judge who gave that order knows the law in making that order. How long will it take? So we may see a situation where, just like in the case of the governor of Anambra State and the governor of Rivers State, you will see a situation where the PDP will contest the governorship election, and then later one of the courts will tell us who the candidate actually is.
But the party will be recognized as having participated in the election. So it depends on who now.
Yes.
But if you look at, the court also says that, if you take a look at the precedent in Gige's case, from the point of law, that doesn't say he wasn't governor, but what he did cannot be undone
at all.
So now that this decision has come forward, so many things have happened, and so many things will before the elections are finally conducted. In the case of any of these governors, if they happen to be indicted within the space of time, does it disqualify them from participating in the elections, even if they were to participate in it?
I guess, let's be very specific now. We have a situation, for instance, there are calls, we've been read in the newspapers that EFCC is going after some of these governors. And right now, there's no immunity. Now, if they get cornered and EFCC is able to pick them up, charge them to court, while they don't have any immunity, I believe one of the grounds for disqualifying a candidate is when you have a criminal charge hanging on your neck. And so such a person cannot be competent or qualified to be presented. No party will pick somebody who has a criminal case hanging on his neck and present that person as a candidate. Because if ultimately the decision goes against him, what happens? Except, of course, I mean, in a situation where maybe by another court pronouncement, the person has a criminal charge hanging on his neck, he finds a way to contest, and then the immunity covers him again, and just like Abia State.
Okay.
I mean, there was a case. I mean, even
before
the court of appeal. Yes, before, and then the day he was sworn in, that ended the case.
But look at this scenario, because those also argue that even if they were indicted now, if they go back, if this judgment says, well, go back to what it was before, that means it undid the High Court and Court of Appeal decisions, or perhaps if some were to anchor their argument saying, well, based on that primary, because as at the time the primaries was conducted, they were righteous. Okay. So whatever indictment is on them subsequently wouldn't matter.
No, I beg to disagree. My disagreement is this. You see, primary elections, I mean, it's just like saying the candidates of parties who have never been governors, they can never be covered with immunity. The peculiar circumstance that somebody like Jimmy Priscilla or all these other governors have found themselves in is this: they are no longer governors up to the point of election. If for instance this Supreme Court decision had not happened, then nobody would have been able to pick them up.
So they cannot invoke the immunity
No, they
that they would have had,
yes,
assuming they were still in office at that point in time.
Exactly. So the fact that you had won a primary election does not cover you, does not give you immunity, because you are not yet governor.
But the swearing in that they took at the first time, the oath of office subsists when they come in.
That oath of office died by this Supreme Court judgment, because the first one subsisted up to the point when they contested election, won again, and now this tenure was elongated, and then the Supreme Court now says no, they ought not to have been there from May 29th. That immunity ended that day, and they are just like you and I now.
Let's quickly consult, Chamberlain, the Nigerian in you one more time.
Yes.
You know, would you advise, is it politically expedient, is it wise for us to conduct fresh elections in Kogi? Haven't spent so much money.
Well, it's not about money. I think it's about peace and democracy. How would the people feel? I don't think we should look at the costs of the elections if we really want to make progress with democracy. The Nigerian in me says there should be fresh primary elections, there should be a fresh election in Kogi State, so that there can be a breath of fresh air.